The court should dismiss count one because the superseding indictment fails to state an offense and lacks the required specificity. Because count two is inextricably tied to a violation of a predicate offense, in this case, count one, this court's review of the sufficiency of the indictment rises and falls on count one. Dismissal of count one would necessitate the dismissal of count two.
That I agree with, by the way.
Yeah, I mean, there's no way around that because it's the same. I mean, obviously, it's an in utero death attached to the person you've allegedly killed. So,
because the in utero person isn't going to law enforcement. I mean, they're not born yet.
Probably not going to be a good witness. Okay. And then they're restating that in a number of different ways. I wanted to focus on some kind of the new stuff. And again, it's a jurisdictional issue. You can't go to federal court just because you want to go to federal court. You've got to have some specific jurisdiction. And in this case, they're using obviously the USC sections that have been cited.
Now, and let's talk about the deprivation rights. Let's go backward a second, just because killing somebody, okay, and this happened in civil rights cases. We said a lot of times in civil rights cases, dealing with minorities, killing somebody takes their life, right? It takes their breath away from them. It takes the ability to live away from them. It's not murder. Murder isn't the charge, but it's a deprivation of civil rights, and the civil rights is your right to live. All right. So he is being charged with depriving Sandra Birchmore and thus her child deprivation of their civil rights, the right to live, by committing the homicide, committing the murder. All right. So just so everyone understands that framework. But to get to that point, what this defense is saying is that we haven't gotten the specifics to give you the jurisdiction to charge the deprivation of your right to life federally, because you need to have a predicate or initial federal offense, such as was pleaded here, specifically pleaded here, the going to tampering with a witness. So what they're saying is that you just can't tamper with a witness. You just can't have a deprivation of rights unless you can show the specifics of the tampering with the witness that we have to defend against. Does that make sense, everyone?
Yeah, raise your hand if that doesn't make sense.
I wish we had that like Zoom. You could raise your hand.
I know there's a way to make it even more interactive than it is, but yeah, it's not quite that interactive. So the second chunk here where I've highlighted, whereas here an indictment repeats broad, generically stated statutory text without descending to specific factual allegations, it violates Mr. Farwell's rights under the Fifth and Sixth Amendment and federal rules. Obviously, these civil rights-based claims, I mean, your life is kind of the ultimate civil right. So it just seems it seems funky when you think of it as a murder and a civil rights case. It sounds a little odd. Okay, it's essential to the conviction under this code that there be proof that the communication at issue, i.e. the communication the defendant allegedly sought to prevent, would reasonably likely have been made to a federal law enforcement officer or federal judge. Here, the superseding indictment fails to even allege that the offense was committed with the intent to prevent the communication by any person to a law enforcement officer of the United States as required under the code. The statute's requirement that the communication be to a federal law enforcement officer is a necessary element of the offense. It is neither surplusage nor is it redundant with the requirement that the subject of the communication be a federal crime. I agree 100%, and I want to see how they get past that. I mean, do they have evidence that there were phone calls made, that there was an outreach of any kind to a federal official?
Well, it could be that paragraph 7, the person who received the call may have been talking to somebody, and then remember the theory is that if they got to Sandra Birchmore to interview her through somebody else, the federal officials, or they were looking at her and she could have been interviewed because maybe there was a federal investigation or feds had been notified, that therefore that would be tampering with the witness, leading to the violation of her civil rights, leading to hence this indictment, which would be valid. That's how I anticipate the feds are going to argue it, that they had an investigation going. And remember, it's interesting because it's a federal officer or employee of the federal government, or somebody who's authorized to act for them, right? Who's authorized to act for them,
Okay, give us
as
an example of that.
or an advisor or a consultant. Okay,
Somebody
so
that is not officially an agent of the government, but is
well,
somehow an extension of an agency.
retired FBI agent Jodine Weber, retired FBI agent Michael Easter is brought in on a case and is paid as a consultant on a case, right? Then they become an agent of the federal government for the purposes of the tampering statute.
What if you know, let's say, Jodine Weber on a personal level, but you also know she was a former FBI special agent, and you talk to her about this situation? Is that gonna work? Is she gonna come under that umbrella?
I don't think so. I think you have to be an advisor or a consultant. Now, an advisor is interesting because, for instance, my husband is an advisor to the New York State Police. It doesn't have to be a paid position. So, are you called and did people pick up the phone and pick your brain from the federal government, for instance, and therefore you're advising them? So that's a pretty broad
Yeah, I
reaching,
just I
you
haven't done
know,
the case research to
research
know
on
if
that.
how
Yeah, that's
tenuous it
pretty.
can be.
Yeah, and I, it's really, really interesting.
Maybe
Um,
I'm talking to her because I anticipate with her connections, her background, her history, that she'll be the conduit I need.
yeah,
I don't
that's
know the
right.
case law, but
I,
I think there's an argument there. Not that
well,
Jodine Weber was involved, but
well,
you
no,
know.
no, we're just discussing that. It'd be interesting to have her on when the hearing happens, to talk about that
Yeah.
because the words of the statute and the words of the U.S. Supreme Court case that they cite aren't exactly defense. Let me just say, the defense, has put in other cases which does expand who a federal government officer is, and that could be somebody serving as an advisor or a consultant. So that
Yeah.
becomes really interesting.
Yeah.
Were they an advisor or a consultant in a Karen Reed case, and somebody thought that maybe a friend who took the phone call was going to call somebody in the Karen Reed case, who was advising the federal government but not an employee. I mean, this has really got a lot of tentacles here, but again,
Yeah.
it's not a frivolous motion because it's going to make the government kind of have to put down a theory.
They're gonna show some of their cards for you
Right.
poker players.
Right. They have to show some of the cards, right?
Let me ask you this. What if I'm talking to this person who's former FBI, and I say, I hope, you can lead me to the right person, or I hope that you can send a message. So does that increase that connection to the point that it counts?
I don't know because
I don't either.
I don't know. Are they an advisor? Well, they're not really an advisor. Are they consultant? No. But are they the conduit that you get to the FBI, and therefore somebody finds out that you've reached out to somebody to say you want to talk to the FBI? I think if the feds have somebody who says, I was going to reach out on her behalf because this was wrong to talk to the FBI, I think that may do it. I think
it's a pretty darn good argument. I have not done the case law research.
Yeah, but we'll have to look at it. Yeah, we'll have to see what the feds actually say. Wouldn't that be interesting?
Yeah. Who cares what we say? Wonder what the feds say.
Right.
So anyway, the conclusion is the complete omission of this statutory element renders the superseding indictment fatally defective and must be dismissed. So again, that gets back to the original point we're making, which is what are they going to have to tell the court to satisfy them that they have what is necessary to overcome that hurdle?
Right. And the intent, and has to be, remember, he has to have intent. This is tampering is an intent crime. You have to have an intent to tamper.
Yeah, it's a specific intent crime for those who are saying, well, is it general intent or specific? It's specific intent.
Right.
And we can have a discussion on the difference someday. Moreover, as charged, count one is overly expansive, suggesting a grand jury might have indicted and a trial jury could convict if the defendant intended to prevent communication to a law enforcement in general without any likelihood that the communication would have been to federal law enforcement. We know there's no doubt there was the intent regarding state law.
No doubt in my mind. How about you?
No, I think that's a certainty, and at least one person, Matthew Farwell, also believes that to be true. But again, for purposes of this motion and the federal claim, so what? So what
Yeah.
if there was that intent for the state level? So what?
And they're saying, and what the defense is saying is like, we have the discovery, and you haven't shown us that anybody in the whole case was talking to the feds or threatened to talk to the feds. Yeah, that's what they're saying. They're saying we have nothing.
If they'd said somewhere in the discovery or something, yes, she spoke to retired Special Agent Jodine Weber. I mean, something that would create at least a connection. I think the court would feel better about it. But at this point, and we've not seen the discovery.
Right. And we don't know about the investigations. Even in the Karen Reed investigation, as I said, there was always an issue. What came first, the chicken or the egg? Did Reed come first, or did Farwell or did Birchmore Farwell investigation come first? Right. And so we don't know. And the feds don't give things over, as we know, even when you're indicted by them. Remember, they don't have to give you. You get discovery, but you don't get a lot of discovery in a federal case. So I think what this is not only an interesting motion, but it's also a motion to force the federal government to give what they don't usually give in cases, which is a discovery. I mean, a lot of times your police reports aren't given until they're on the stand. You don't get police reports with an automatic in federal cases.
That's a very interesting point, because they may have that secondary benefit, that they figured, hey, worst case scenario, maybe we're going to get some goods here that we might not normally get. I don't know.
Yep.
Let's see. Oh, so whether it's state or federal, this is precisely what the Supreme Court cautioned against in Fowler when it explained that expanding the code section intent element to prevent communication to law enforcement in general would sweep in many instances of witness tampering in purely state investigations and proceedings, and would expand the scope of the statute beyond the instances that Congress intended. I get it, makes perfect sense, and just makes me more pissed off at Norfolk County for not doing their job.
Right, exactly.
They're the ones causing this,
and they're relying, and they're causing it, and then they're relying on the state medical examiner who's saying that it's a suicide. And by the way, I don't care what anyone else says. I don't care if you have 50 peer-reviewed people saying this is not a suicide. We're standing by our opinion.
That's right.
Okay?
That's right.
So if the state medical examiner in Boston would say, no, this was a homicide, then Norfolk County would have to do something. But they're allowed to sit there and say, we don't have to do shit because, or the state officers agree with us, or we agree with them. That's all.
Yep. That's very frustrating.
They didn't in Karen Reed, but that's beside the point. They took the opposite approach.
Yeah, really. That's right. Funny about that. Then they go into reference on the facts of Fowler, but this was the quote within that case. The government must show a reasonable likelihood that had the victim communicated with law enforcement officers, at least one relevant communication would have been made to a federal law enforcement officer. Only if it is reasonably likely under the circumstances that, in the absence of the killing, at least one of the relevant communications would have been made to a federal officer. So there's the standard, reasonably likely. To me, that's pretty easy to meet.
Yes, I think that's a very light standard for the purpose of.
That's the Fowler case, and that's law. To be clear, Mr. Farwell denies killing Ms. Birchmore, and the government failed to properly allege that any killing was committed to prevent at least one relevant communication to a federal officer. So they have to, good lawyering also involves admitting when something goes against you, case law is against you. You have to raise it, hopefully distinguish it, and move past it. And they've done that a couple of times, a couple of different cases here. We're going to get up to another one here where they get into a very important definition by the court and then say, but, not quite applicable here. And that's just part of it.
And good lawyering, as we just point out, also involves, you may have your first target to dismiss the indictment and have, or you may have the second target to get more information as to what I'm actually defending, because, I really know, but I need you to put it on the table. And you may have the third goal is to get more stuff that you wouldn't normally get until you get closer to trial, because it's not a death penalty case. Therefore, you're not getting as much as you would normally get. Remember, the death penalty is taken off the table here.
Yeah, so it's basically using it as a discovery tool, even though,
you don't know. It could be a dismissal or a discovery tool.
Yeah.
But good lawyering takes all that into account. I mean, people say, well, you lost that motion. But in losing the motion, you may have gotten an order that says you have to do X, Y, and Z, federal government.
Yep. Again, more words from Fowler, and in this case called Russell, which I think, let's see which one came first. I think Russell came after Fowler. Anyway, these are the facts that must be pleaded in an indictment, because absent these facts, it will be nothing but a subsequent guess as to what was in the minds of the grand jury at the time they returned the indictment.
I think Russell must have come first because it's at 369
Oh, it is,
U.S.
and the other one's
Fowler's
at
at 563.
Very good.
Yeah.
And so these are, remember, this is in the context of a grand jury indictment too. So they're looking at it from their perspective. It would be nothing but a subsequent guess as to what was in the minds of the grand jury at the time they returned the indictment, and the defendant could then be convicted on the basis of facts not found by, and perhaps not even presented to, the grand jury which indicted him, which would deprive him of a basic protection, which is the guarantee of the intervention of a grand jury.
That happens all the time, by the way. Okay, that you go to and you have an indictment, and then afterwards the government has a completely new theory of the case, and that wasn't presented before the grand jurors, and the courts allow it. You make a motion to dismiss on the basis that wasn't presented to the grand jury, and the court says, "I don't care." So.
Yeah, well, that's, the federal grand jury process, I admit, is a little more deliberate than the state. I think grand juries are arcane and a waste of time. Just get to the information or the complaint, however it's brought about in your jurisdiction, and move on. Get to the jury. Ultimately, they're the ones who are going to make a decision. That's just me, though. So, concluding, whether the communication the defendant sought to prevent reasonably likely would have been to a federal law enforcement officer, it cannot be known whether the grand jury authorized a valid indictment charging a federal offense. So yeah, if the grand jury is shooting in the dark, then a jury ultimately could be as well. But the reality, as you state, is that it's not going to go sanitized from grand jury indictment to a jury conviction. There's going to be a little something coming along the way to flesh out whatever the grand jury did not get.
Right. If they didn't get it at all.
If they didn't get it. Yeah.
Yeah.
Let's see. Oh, this is the case I thought was interesting. The United States versus Baugh. Recognizing a district court split on whether an indictment must specifically allege reasonable likelihood of a communication to a federal law enforcement officer. The judge said, when they start citing judges in particular, sometimes they do that because that judge is the opposition and it supports their case. The indictment need not allege a reasonable likelihood to pass muster. Ooh, that doesn't sound good. Significantly, Baugh is not controlling precedent. Oh, there we go. So here's a case of where you raise Baugh because you have to. You can't ignore it. And it stands for a proposition that really does not help your motion. So you just say, wait, it's not controlling precedent. It's out there, but it's not controlling. And so that's what they've done. They go on to cite Judge Saras again. Explicitly found that the indictment were there appropriately apprised the defendant of the charged conduct, where it included specific descriptions of defendants' attempts to conceal their conduct from state and federal authorities by, among other things, monitoring law enforcement communications, forging records, lying to investigators, and destroying evidence.
I would argue that killing somebody comes into the category of destroying evidence, and that case is helpful to the prosecution, despite the defense's ability to try to separate it from.
Yes. So in that case, the defendant tried to conceal conduct by monitoring law enforcement, forging records, lying to investigators, destroying evidence, but not killing anybody. So I think that's the ultimate attempt to conceal your conduct, isn't it?
Right. Tampering with a witness, concealing conduct, and tampering with witness at the same time.
Tampering with them till they're dead. That's tampering already.
Right.
The court found that, quote, this is enough to put the defendant on notice of the charge that a federal investigation was reasonably likely, that is more remote, that is, I like this, it is more than remote, outlandish, and simply hypothetical. And I think you can distinguish that case on its facts. It clearly wasn't a murder case.
No, but is if the feds found out about the conduct going on about trafficking of children, is it reasonably likely they could have a case that they could have gotten involved? That's all this stands for. Is that a foreseeability that
I'd
there would be
say, yeah.
some federal involvement somewhere, and therefore that's enough
Yeah.
to trigger the tampering and the deprivation of civil rights together, and give the defendant enough of a notice in the indictment what he's defending against.
Yeah, and it goes beyond, what they dealt with in Baugh. So that's how I would distinguish it anyway. We'll see what the court does with that.
So yeah, we're playing both here. We're playing both defense attorney and prosecutors, and the court's ultimately going to have to make a decision. But you can see how the law leaves a lot of room here, for interpretation and decision making. But having said that, I will say again, this is not a frivolous motion because
yeah.
of that interpretive value in various cases.
What you find, what law students find, and when they start the process, research is different now than it used to be back in the day, Sonny. Where I would spend 10 hours in the law library with books
right.
piled in front of me, opened to various pages
and the pocket sheets
from
in
the
back.
The pocket part. Damn the pocket part. Because the pocket part is actually a subscription service. Because when I first started practicing, I bought the whole California library. I was a geek. And the pocket part is a subscription service because, hey, the law changes
every year.
And so you would get this sometimes thin, sometimes thick pocket part that would slide into the back of the existing text. And if you missed looking at that, you could embarrass yourself.
Yeah, and I remember having a part-time job where one of the things I had to do for the law office, the main thing, because they had this huge law library from all over the United States, was put the pocket parts in. They're like, holy shit. So when I became a lawyer and Lexus was there, I was like, we're not having a law library. We're just having Lexus. Okay.
Exactly. Talk about grunt work. That's got to be the worst, putting the pocket parts in, keeping that up to speed. And it's not a cheap subscription. So now it's all electronic, which I kind of
and not only was the subscription, you had to buy office space to house all those books.
Oh yeah,
right.
Yeah. And so you have your in office law library, and maybe this many of those books are ever used regularly, right? The rest are just great for when you do an interview and there's a nice backdrop of books. But I like touching the books, and I just do, but I'm old.
Well, I still bring the rules of civil procedure of whatever the state or the feds in hard copy with me, because I think sometimes it's just easier.
I think so. I think so too. And I don't like relying on electronic that could glitch and you're done, and where the hell did it go? So anyway, that was a long way of going about that. What were we talking about?
The yellow part there.
How the law changes.
How the law changes. How the law changes constantly, and how it's interpretive.
And that's why, it's a cliche, but there's a lot of gray area. And if there weren't, then attorneys would have no jobs.
Well, look at Miranda. Let's take for our viewers right now, our members, Miranda, right? You have to give Miranda rights, right? My card, my law office card has Miranda rights in the back. I tell clients
if you're being interrogated and if you're in custody.
Right. But exactly, what's in custody? What's interrogation? What are you a suspect? There's so many changes to it that you seldom see, and whenever we see something thrown out because Miranda wasn't done properly, it's like, what? It's where Miranda still exists, in some form or matter, because there's so many interpretive changes to it, or exemptions, or fooling around with it, some would say.
And it's going to grow. Every case is different, and when you hear about a phrase on all fours, which is always, usually exaggerated, it just means that you've found a case that is so much like the case you're arguing that how can we even talk about it? Well, clearly they weren't any that are quite like this case, or we would have seen them cited. But in terms of the Miranda, we just saw the Mangione case where they tried to get rid of some of the statements made, not the ones that were recorded in that conference room, because they did limit those.
Right, on the basis of the wiretap statute.
Yeah, because it's a two-party state, and he didn't give consent, and it wasn't noticed. But when he was surrounded at McDonald's by all those cops, and he was answering questions and all, was he in custody then? And he was certainly being questioned, but was he in custody? And that was the issue, and ultimately it lost. If he wanted Now, maybe they would have arrested him if he said, "Have a nice day, guys," and started to leave. We'll never know. But you're not in custody if you can leave.
Right.
So anyway, let's see. Superseding indictment fails here to provide notice to Mr. Farwell that the communication he sought to prevent reasonably likely would have been to federal law enforcement. It fails to provide notice of whose communication Mr. Farwell allegedly sought to prevent. Well, I guess it could be Sandra Birchmore or the person identified in paragraph 7.
Right.
The lack of specificity prevents Mr. Farwell from being able to defend against the indictment and from twice being placed in jeopardy for the same offense. Moreover, the omissions would permit Mr. Farwell to be convicted on the basis of facts not found by or perhaps not even presented to the grand jury which indicted him. I always think that we've talked about it. I think that's
not
although as big a deal as it should be.
You did hear the double jeopardy argument now raise its hand, its hand and say double jeopardy because you're not telling me what I have to defend again. Therefore, if I have to take this to trial and defense and then I have to get re-indicted for another type statement or another tampering with somebody else, I didn't know,
was it that person or was it a different person?
Right. So you did hear this just starting to raise this little ugly head here. It's not ugly. I mean, it's a perfectly valid, but it's again double jeopardy. People always ask, well, how can, for instance, Mangione be indicted on state crimes and federal crimes? You get acquitted on the state crime, and then you get indicted by the feds, or you get acquitted by the feds, and you get indicted by the state, because they're two separate individual governmental entities, and therefore double jeopardy doesn't apply. All right, but that's not what most people think of. If I'm acquitted, I'm acquitted.
It's a legal fiction, that you're just kind of creating that, and think about the Rodney King case. Think about the O.J. Simpson, acquittal criminal found civilly liable, or vice versa, and the same core, it's the same nucleus of operative facts, right? So it makes people wonder, what's it, just some legal sleight of hand? How can that one set of facts find you innocent or not acquitted here and yet used against you in a totally different? How is that not double jeopardy? I get that confusion and the criticism. I get it.
So one of our viewers, Sandra 8271. So basically, if Morrissey had charged Farwell like he should have, Sandra won't have justice. Well, we're not saying that, but we're saying that this motion, if it's granted and without leave to, if the court finds that it doesn't give the statutory basis of tampering that he can defend again, and doesn't allow the feds to correct it, then that's going to be a problem. I mean, so you got 3 steps here. The motion gets granted. The motion gets granted in toto, or the motion gets granted and says, you government, you can fix it under, and maybe the government can or they can't, that's, or, the motion just said, the judge just says, go away. Go away, defense.
And I think, again, we try to put these things in a vacuum where the judge in the federal case won't take into account that the only remedy left for Sandra Birchmore is federal because of the way the state has failed to act. I think the judge takes into account. I just do.
I think he or she is going to take it into account, whoever ends up with this case ultimately for trial.
Yeah. So I don't worry that much that she's not going to have a remedy. She will have justice. How it unfolds is kind of interesting, though. One last reference.
But this does raise questions because, as we said, it's not frivolous.
No, I think it's good lawyering. They're representing their client, even though he's a douchebag. Even a douchebag has a right to a defense.
Yes,
you can quote me on that.
Yeah, everyone has the right to defense.
Assuming arguendo that the call referenced in paragraph 7 of the superseding indictment provides the basis for the communication element, it alleges neither a communication or likely communication to federal law enforcement nor even a federal crime. As charged, the cryptic form of indictment here leaves the prosecution free to roam at large, to shift its theory of criminality so as to take advantage of each passing vicissitude of the trial and appeal. So some nice language quoted there from the Russell Court, I believe that one is. Anyway, Let's see if there's more. You get the picture. You can hear the theme.
So now the
theme
theme is the theme is repeated and repeated. In case the judge didn't get it the first time, the theory behind trying a jury trial is you tell them what you're going to tell them, you tell them, then you tell them what you told them.
Exactly.
And same thing is happening here in this motion.
And here's one last salvo as to the specificity they think is important. In addition, central to every prosecution under the statute is the identity of the person whose communication the defendant sought to prevent. Well, I mean, I don't know if they're referencing the person from paragraph 7, not identified, because obviously Sandra Birchmore is identified. The government must establish a reasonable likelihood that the person whom the defendant believes may communicate with law enforcement would in fact make a relevant communication with a federal law enforcement officer, and that there must be evidence, not merely argument, of the witness's cooperation with law enforcement. So I think they must be talking about this other person. That's just my guess.
So I think we're going to find out pretty soon.
Yeah, hopefully we'll find out next week, but
you may even find out with the superseding indictment if the feds think they have an issue and want to say, okay, you wanted it laid on the table for the public. Here's
our second superseding indictment.
Yep. Possibility, making things moot.
Okay, well, that's all going to unfold one way or the other next week. Either it's going to happen or it's not. And if it's not, then we're going to learn more about why it's not.
Right.
So we didn't get into.
Good job, Michael. Good job.
Likewise.
Good job reading the whole thing, though. You actually, because you're the voice actor, so we let you do the reading.
I'm just reading the words. This is actually pretty well written.
It is
pretty well written. We didn't get a chance to get into the affidavit. I think they call it Ray detainment.
Right.
Basically, it's why the feds say that this guy should have been, kept and is kept behind bars pending the resolution of his case. It's just some
unbelievable. It's so detailed.
It's
You know how we talked about that the trials are the sidebars, and trials are the most important part of a trial. That's where you really learn what's happening. Well, that affidavit of detainment,
it's their argument. I mean, it's the facts based, the facts upon which they base their belief that this guy should be convicted, and it doesn't hold anything back. Maybe we'll have to get into that. We'll see. Maybe we'll do another one of these member only next time.
Especially if this doesn't go right next week.
Yeah. Otherwise, next week we'll be busy doing that. But this one for non-members, first of all, we like doing this for members because we do get some interaction, which is nice. But we'll break it up and release it wide over the weekend, which gives everybody a chance to kind of benefit from our looking at this. So we may do that again next week with the detainment document, which is crazy. So.
All right. Well, thank you. I'm glad I joined you again. This is my second time joining the members. I've done one tape members, and I keep promising I'm going to get back to the Stephanie Vilko case, but I keep getting more information. So I have to be able to put that together in a manner of which I want to put it together for the members. And I just may end up taping it myself and putting it out there because there's just so much. And there were so many people that were involved that I think they would like to see it put together, and then they can take it from there.
Yeah, and the reaction to it was great, and people were doing some legwork, even from the first show you did. Right. So, all right then, don't forget tonight, if you're watching this during the member only, tonight we have a follow up on Richens. We'll see where she is. The court today was cut short today.
Right. Correct.
Some evidentiary issues. First, the judge had an hour-long calendaring issue, so they went for an hour, stopped for an hour, and then when they came back, he said, "You're done for the day." Some evidentiary issues. I'm going to follow up on that. I think it's related to a witness, maybe some other stuff, but we'll figure that out. We'll talk about it tonight.
But the reason why he had to end for the day had to do with the other case that apparently he had to go to the hour conference on that had to be attended to. So it had nothing to do with Richens, from what I understand. Mm-hmm. But there was also some really interesting issues that we want to go on about a witness talking about jail calls and what happened. I can't wait to discuss that tonight. I know you're going to pull that clip.
All right, then.
Fun. All right, everybody. Nice seeing you on a Wednesday afternoon or a Saturday afternoon or a Sunday afternoon or any afternoon.
All righty. We'll see you next time right here on Justice Served TV. Please try to do the right thing.
Riding flames, they charge with mine.